All right, this is Citizenship and Immigration Attorney Parviz Malakouti. Today is October 16, 2025. This is our 42nd mobility space. And today we're talking about genuine links and connection to second country of citizenship. Now, genuine links is actually a legal term of art that's written about in a lot of case law, specifically European case law. We'll touch on that a little bit too, but I'm referring more to genuine links and the concept of connection in the broader sense. And the reason we're interested in this is because we want to have our finger on the pulse of where citizenship is going, treatment of citizenship by countries, and specifically where certain types of citizenship are going, right? And so we've seen, citizenship by investment, other types of citizenship kind of be under attack, be picked at a little bit by countries trying to not recognize some of the benefits that a person that has that citizenship should have. And so we want to talk about all of this today, right? So as a reminder, this is our 42nd mobility space in our series of 50. We're doing 50 mobility spaces this year on the hottest topics in dual citizenship, freedom of movement, and of course, sovereignty and passports. The rules are, there are no rules. Anybody can speak. All you got to do is hit the request button. I'll approve it right away. You don't need to wait to be invited to speak. Cannonball in. If somebody says something that you disagree with, or if you have a burning, desire to piggyback on what somebody says, just come right in. Absolutely no problem whatsoever, right? So genuine links and connections. So I thought I'd start off this space just by laying a little bit of groundwork with the Nottebohm case and a little bit more context about modern day, what people are dealing with different types of citizenship and trying to live around the world and obviously obtain and be able to actually use as many benefits of as many citizenships as possible, right? So Nottebohm is a famous ICJ case, International Court of Justice case from 1955. And it's about this guy named Friedrich Nottebohm that was born in Hamburg in September 16th, 1881. He was born German, okay? So he's a German national by birth. In 1905, when he was a young man, he went to Guatemala. He followed his brothers there to establish himself commercially. And he went into business with his brothers. They had a company called Hermanos Nottebohm, and they were pretty big. They were dealing in plantations, coffee exporting, banking, commerce, etc. Okay, he was very successful financially in Guatemala. Fast forward again from 1905 to the late 30s. Obviously, the world was steaming towards World War in the late 30s, and in 1939, Nottebohm, recognizing that he has German nationality and that would make him vulnerable, he applied for naturalization in Liechtenstein. Okay, now Liechtenstein wasn't a country that he had no connection to whatsoever. He did actually have at least one brother that lived in Liechtenstein and a few other more distant family members. But he applied for what I think could be called kind of their equivalent of citizenship by investment in Liechtenstein in 1939. And if anybody's interested, I have a little timeline of the naturalization, his naturalization timeline that I tweeted, and I linked it below this or to the space tweet. Okay, so in October 9th, 1939, Nottebohm applies for naturalization. October 15th, so just 6 days later, 1939, the Commune of Marne approves Nottebohm's application for citizenship. How's that for expedited processing, by the way? 6 days later. October 20th, so another 5 days later, 1939, Nottebohm takes his naturalization oath ceremony and receives his naturalization certificate. And on that same day, Nottebohm received his Liechtenstein passport. So for anybody who's not counting, that's 11 days in total, okay, from applying for naturalization to being approved, getting a naturalization oath ceremony, and then getting a passport, okay? Now, just as a side note, what kind of investments are we talking about? So he paid 25,000 Swiss francs, okay? And I'll do the modern day equivalents in a moment. And then, so he paid 25,000 Swiss francs to the Commune of Marne, okay? He paid 12,500 Swiss francs to the state, okay? And the equivalent of that adjusting for inflation, excuse me, is about $193,000 USD in today's dollar. So I found that kind of to be interesting as well, because that actually does put the total amount in the territory of what at least Caribbean CBIs used to go for. It's a little bit less than what they go for right now. but obviously it's in between what these three African CBIs cost nowadays and what the Caribbean CBIs cost, in which about $250,000 without the application fees. So he did that in 1939. Okay, he picked up, or at least he thought so, Liechtensteinish nationality. Okay, fast forward another 2 years, Guatemala declared war on Germany. Okay, and then they immediately started taking provisional wartime acts, okay, against German nationals. And so another 2 years later, Guatemala arrested, detained, and expelled Frederick Nottebohm. And they seized his property, and they refused to readmit him into the country, to Guatemala. In response to that, Nottebohm requested diplomatic assistance, consular assistance from his country of nationality, right, which is Liechtenstein, and Liechtenstein brought a case against Guatemala in the International Court of Justice, okay, which produced this opinion, which I've also linked. And the opinion is from April 6th, 1955. Okay, so we're not going to make this like a hotty-toddy academic discussion. I just want to basically lay the groundwork, okay, of the facts of the Nottebohm case, okay, and then basically what occurred here, okay. And it's an interesting opinion. I recommend anybody who hasn't read it to read it, okay. But the bottom line is that the court comes up with what they consider Nottebohm's effective nationality. Okay, so not the nationality that he had, according to Liechtenstein, right? But basically, they basically the court takes Guatemala's position that Nottebohm effectively was still a German national because of a lack of factual ties, okay, and other ties, commercial ties to Liechtenstein, right? Interestingly, and I tweeted about this before, the shortness of the timeline of naturalization is not actually cited in the court opinion against Nottebohm and Liechtenstein, but rather they go actually to the ties that the court considers that Nottebohm had. Now, I'm going to talk about this later in the space, but I believe modernly in 2025, period of residency before applying for naturalization is an important relevant factor. We've already seen a few instances in real life, actually, in which countries have considered or have basically imposed some minimum period of domicile or residency in order to recognize a person's citizenship of another country. And I think that that's only going to grow. So in my opinion, I think residency is modernly a robustness infusing feature of naturalization, especially when there's a relatively short period to naturalization eligibility of a person. But the bottom line is Nottebohm and Liechtenstein lost that case, okay? That's a seminal case from 1955. There's been a few cases, seminal cases in the EU since then, okay, which have rejected the concept of genuine links, okay? Micheletti is one of them. I forget who brought it up in our last space. It may have been Jay or David, forgive me, but maybe both of you brought up Micheletti as well, and the concept of genuine links, the legal term of art, was rejected. I believe that the colloquial idea of genuine links, okay, so connection in fact to a country, is very much relevant today, irrespective of these court opinions in the European Court of Justice. I think countries more and more, especially the more that they are antagonistic to, let's call them easy come citizenships, okay, and in that category, I would put citizenship by investment, number one. Number two, citizenship by merit, okay, especially if that merit is going to have a financial underpinning, meaning the merit is that they're a big investor in the country. And thirdly, to a much lesser extent, but I still think it's worth speaking about, to citizenships that are acquired by descent, but distant descent, okay, talking about citizenships in which a person is applying for citizenship based off of, let's call it, a great grandparent or beyond. Okay, so I think, okay, that this is a very relevant concept, and I think this concept of connection to the country is picking up steam more and more as more people get CBIs and as more countries become aware of CBIs. Now, there's a few examples here that we could talk about. We've spoken about these, in bits and pieces in previous spaces. Okay, but one of the first ways to not recognize and ask, a benefit of a person's, citizenship, is by stripping visa-free access. Okay, so we've already seen, of course, a number of times Vanuatu got their visa-free access stripped by the EU. In large part because of perceptions of a lack of due diligence in Vanuatu's application process for their CBI. Dominica had their their visa-free access stripped to the UK. News just came down, I think it was 2 days ago. Okay, Botswana, which is the most recent country to announce a citizenship by investment program. The UK, just like that, announced effective immediately that Botswanans no longer have visa-free access to the UK. Now, in that announcement by the UK Home Office, they referenced visa overstays from Botswana, in their kind of rationale reasoning. They didn't reference the announcement of a forthcoming Botswanan citizenship by investment program. But I and others, it wasn't just me, a number of my followers and other people also thought that the timing of this was suspicious, at least, to say the least. So I think it's fair to say that there's a good chance that the UK stripping of Botswana visa-free access was maybe at least in part due to Botswana's announcement of the CBI. That's speculation, but that's my opinion. News also came out fairly recently, and I think King, if I'm not mistaken, I think King of Sardonica alerted me to this, that some of that in the Caribbean, the new regime of trying to have residency, so springboard satellite residency of countries in the CARICOM and right of authorization of work, without having to apply for a permit, that this was going to exclude people who had those countries' citizenships if they obtained it by investment. And that particular news was news to me in this instance, but what we have spoken about that, previously. And in fact, I mentioned both in the instance of the EU as well as CARICOM, which was trying to get together kind of a regime that's similar to the EU, like a robust freedom of movement within, freedom of movement, settlement, and work within the bloc. I had mentioned previously that I thought that this might happen, but King, as far as I'm concerned, King broke that news. So that's another one. Of course, we have, as a third example, the stripping of E-2 treaty visa eligibility. So E-2 treaty visa is an investor visa in the United States. It's a non-immigrant investor visa, meaning it's not the EB-5. And in 2022, U.S. passed legislation that said that if you are applying for an E-2 treaty investor visa based off of a citizenship that you acquired by investment, you no longer qualify unless you have first 3 years of domicile in that citizenship in that country of citizenship by investment before you apply for the American visa. So how do I read that? I read that as a mandatory, as a new requirement saying, show us your ties to the country. And the way we measure the ties is, have you been domiciled there, right? So that's a third one. And then fourthly, we kind of have what I would consider a catch-all category, which is more and more questioning by not necessarily countries, not necessarily agencies, but financial institutions, banking institutions, more and more questions asking how a person obtained a particular citizenship that they are claiming they are, that they have. And so we're seeing more and more people reporting that there's, especially in KYC, AML questions about whether a person got the particular citizenship by investment or not, right? So anyway, that's kind of the context of what we're talking about here, and this is why we're interested in this concept. I'm a citizenship and immigration lawyer. People ask me when they are consulting or when they're clients pursuing a particular citizenship, and if they don't ask me, I tell them this is something you should ask and be thinking about. If I work towards pursuing this citizenship or this residency that, with the eye of working towards naturalization eligibility 5, 6, 7 years down the line, what's the chances that if I obtain this citizenship, that either another country is not going to recognize it for the purposes of a benefit, meaning let's say I no longer get visa-free access to, some country because I got this citizenship by investment, or let's say after a period of residency by investment, And B, okay, they're asking, or they should be asking, what's the chances that the very country that I obtained the citizenship from tries to discriminate against me or throw me under the bus, especially if I'm a controversial figure, if I say something that's unpopular online, et cetera, et cetera. So this is extremely relevant, topic, this idea of how countries are treating people's citizenships and how they're starting to delineate, okay? And this, first of all, ask how did the person get the citizenship? And then B, do we want to treat this person differently based off of the method by which they got the citizenship? So there's a delta that we're seeing that's being formed between citizenship, I guess we could call it citizenship in fact, versus operative citizenship, meaning what is another country recognizing you as? Are they recognizing you as a citizen of that country that you're claiming or not? Are they saying, no, you're not really Italian, you're Argentine, okay, et cetera, et cetera. So that's it. I've been going for about 15, 16 minutes there. I want to start the discussion, and I want to ask some questions. So we got Jay here, we got David here, we got King, okay? Let me throw out the first question to Jay, okay? So Jay, what do you think about, do you think we're seeing more delineation? Do you think we're seeing a trend towards delineation of how a person obtained a particular citizenship? And if so, do you have any thoughts on who you think are most vulnerable?
Yeah, I think we are seeing to some extent a delineation especially between citizens by investment and other citizens of countries, but even to some degree with citizens by descent and citizens who obtain their citizenship through naturalization, ordinary naturalization. For example, with the US, citizens by descent in Hungary or naturalization in Hungary for a couple of years were denied the ability to get an ESTA by the US government because the US government had concerns about Hungary's simplified naturalization program for descendants of Hungarians from other countries in the region. And we're seeing this with the E-2 treaties, as you mentioned, delineation between citizens by investment and other categories. But even with other ways of getting citizenship, if a person is not somebody with a typical profile of a citizen of that particular country, that could pose problems at some point. Let's say they were born elsewhere, or they have multiple citizenships of different countries. Sometimes that could pose an issue. Of course, less so with citizens by descent, but stuff like citizenship by merit, citizenship by investment, citizenship by exception, that would I think I would lump that into the category that would potentially have the most issues, especially the transparent investment programs that are out there.
Yeah, absolutely. I wrote a lot actually about Hungarian citizens by simplified naturalization losing ESTA access. I think that was in 2022 that it started. I have not revisited actually the issue to see if U.S. Department of State put more information, more specific information about why that was the case. But I have my theory, and I believe it strongly. Actually, in fact, I maybe down the line I'll FOIA the Department of State to try to get an idea of why exactly they stripped ESTA. In my opinion, it's not just that Hungary had a wide-ranging, or let's say a citizenship by descent program with wide eligibility. In my opinion, it was because that naturalization regime did not require a background check of applicants, and that is unique in EU and European citizenships by descent programs by naturalization. We're not talking about verification. A lot of countries have processes whereby if you apply for just verification of citizenship, you're not asked for a background check of your home country. And that makes sense largely, okay, because the claim is I was born a citizen by operation of law. So therefore, it shouldn't be that relevant, actually, whether you have a criminal record or not. You're claiming by operation of law, I was born, even if I have a criminal record, before I even, did those bad things, okay? I was already a citizen the moment I popped out of the womb, okay? But the naturalization programs, okay, the citizenship by descent naturalization programs in Europe, all of them, and I'm not aware of another exception. If somebody knows of one, let me know. But all of them, except for Hungary's, require a background check, okay, and retain the ability to deny people based off of the criminal record. Hungary's did not. I still think simplified Nats by Hungary, but I'm less sure actually because I haven't.
I can tell
Go
you,
ahead.
it does not. I've read through the application because I think I said on a previous space, and I'll say it again. I was looking to apply myself.
Mm-hmm.
And they just have you sign and say that you don't have any criminal history. They don't have like an actual background check.
There you go. There you go. Exactly. So they're still not requiring a background check for naturalization. As far as I know, that is unique, okay, among European citizenship by descent naturalizations in Europe. So that's a great point. That's an absolutely great point, Jay. And what does it show? It shows, right? So, okay, if I'm right, if that hunch is right, that in fact was the reason for Department of State's suspending ESTA eligibility for Hungarian citizens by simplified Nats, and we're not sure. In fairness, we're not sure that's the case. I would like to find that out for sure. But if that's the case, okay, that means you have one country, the United States, reaching in and looking past just the claim of citizenship, okay, Hungary's claim of citizenship, not just the person's claim of citizenship, and saying, no, we want to know. We want to take a look at how you got that citizenship. Were you born a Hungarian citizen, or did you naturalize later? And then now, okay, we're gonna strip you of this springboard benefit to the United States. I think countries are more and more becoming comfortable doing that. Some countries, United States obviously has enormous bureaucracy, enormous resources, and there's an enormous appetite to visit the United States visa-free. Okay, so to me, it would make sense that the United States is kind of one of the first countries to try to do those types of things, right? But other countries can, okay, and in my opinion, eventually other countries will at least make the inquiry, okay, if not start making the inquiry and start, kind of categorizing, even if they don't try to, strip away the benefit of people who got the citizenship by a particular method, even if they don't try to strip it away right away, right? I think eventually we're going to start seeing kind of that categorization of people based off of how they obtain the citizenship, with the most vulnerable categories being, as Jay, agreed, CBI, citizenship by merit, okay, and then distant citizenships by descent as well.
Yeah, one of the things that I wanted to bring up was that this also might affect citizens by ordinary naturalization, because oftentimes the denominator that the other countries use is place of birth to determine whether they have eligibility for that benefit or not.
Yeah, possibly. I think I think using citizenship or a country of birth as a proxy for citizenship is kind of like it's like a facial thing. Okay, it's just like, if a person, like an employee of an agency or a border guard or whatever, wants to just kind of get a quick idea of where they think a person's a citizen of, right? They'll oftentimes kind of just look to the country of birth and then operate from that assumption until it's rebutted, right? So yeah, I agree to that extent. As far as I can't think of an instance off the top of my head where a person was born in a country and then and they have they have strong documentation to prove that they're also citizenship of another country, and then the other, a third party country said no, we don't recognize just because you weren't born in the country. It certainly could, there could be instances. It certainly could be coming down the line, but at least from what I've seen so far, countries take the inquiry at least a step further. If they want to deny recognition of a person's citizenship, they'll say, well, you don't have ties, or the naturalization was based off of investment, or maybe it was, for example, we want to look into the circumstances in which you naturalized. You committed fraud in the application. Are you aware, Jay, of an instance, of an example in which a country just refuses to recognize another, citizenship just because the person wasn't born in that country?
Yeah, well, that example that I brought up with Hungary, the U.S.'s denial of ESTA wasn't based on how that person became a Hungarian citizen, but based on where they were born. So, like, if you have a Hungarian born in, say, Japan, who's a child of a Hungarian parent, that person still wouldn't necessarily be eligible for ESTA because they were born outside of Hungary. And I
Right.
don't know whether this is true, but I'm remembering that in some instances, people who are citizens of visa waiver countries who were born in a number of countries that are on the US's naughty list, like Iran or Syria, can also get denied ESTA access. I don't remember this off the top of my head, but that's something that I'm
Yeah, that's
pretty
that's
sure.
how that's right, including those who have visited Iran and other countries on the naughty list since 2011. Yeah, this I get. Absolutely agree with you. I get with what you're saying. This might be splitting hairs, but I would categorize that as specifically ineligibility for a benefit, as opposed to complete non-recognition of the person's nationality.
Yeah,
And again,
yeah,
that might
absolutely.
be splitting hairs, but yeah, it's great point. You're absolutely right. People do get denied benefits based off of being born in a country, an enemy country, or let's say an unfriendly country, as well as the Hungarian example, like you said. Okay, just based off of what I speculate is concerns about the vetting of the people. All right, we got King here, we got David here. Any thoughts, David, about where you think first of all, whether you agree or think or see that there's a trend whereby more and more countries are starting to want to look into, not just say, okay, yeah, you're a citizen of that country, there's your documentation, but no, we want to scratch below the surface and ask about how you obtain
Couple
that.
seconds. Well, what were the last few words? A trend about
No
more and more
problem. I just
countries
want
wanting
to ask
to.
your thoughts on what you think about what we mentioned, and whether you agree that there's a trend towards countries wanting to not just take at face value that a person's a citizen of a country and afford them the benefits, but rather scratch under the surface and start asking, how did you obtain that citizenship?
I don't have any insights beyond what you've already mentioned, so um, I don't have anything to add.
No problem. So I'm going to just continue on. Okay. So I'd like, so I love academic legal discussions. I love reading opinions, law review articles, all that type of stuff. But my North Star as a practitioner is, how do I learn about, these topics and these concepts in a way that this can be transformed into practical guidance and advice. Okay. For me, for my clients, that's my North Star. I think, what does it mean at our level, okay, for the person that's trying to think, think long term, 30, 40 years. Okay, I'm going to be around 50 years. I'm going to be around for a long time. I want maximum freedom of movement for myself. I want to set up my children, etc. And to me, what it comes down to is building connection with the country. Okay. Now you can't go ham on that, right? Because in certain ways you can start trying to build connection with the country, for example, by physical presence. That's going to trigger other obligations. First one that comes to mind, of course, is possibly falling into a foreign country's tax net. Okay. But, you know, ties to countries, it's kind of an interesting thing, okay, in that oftentimes you can kind of build ties to countries that generate documentation, okay, so evidence in the form of documentation that's not necessarily public, but you can hold, okay, and you can have yourself, okay. And I've done this. I mean, one example that comes to my mind, different context, but I think the principle holds true the same, is when we're applying for U.S. naturalization for legal permanent residents that have possibly broken what's called continuous residence in the United States. So in U.S. immigration law and citizenship law, if you're a legal permanent resident and you've been continuously absent from the United States, okay, for 6 to 12 months, that creates a rebuttable presumption of broken continuous residence, which makes you ineligible for naturalization. If you're absent from the country for 12 months or more continuously, meaning without even stepping a foot back in, that creates an irrebuttable presumption of broken continuous residence. So we can't do anything for somebody who's been out of the country for 12 months or longer, okay, unless they fall into one of the exceptions, without stepping foot in the United States. But we have a lot of people, and especially I had a lot of clients since the pandemic started, which, lockdown started in the United States around March 2020, April 2020. People were sent home. A lot of green card holders figured out, well, hey, if I have to work from home, I'm gonna go back to my home country. I'm gonna get some visit time in with my family, my parents. I'll work during the day, okay, and I'll be there. And a lot of those people stayed out of the country for between 6 to 12 months. Fast forward a few years, they wondered if they were eligible for naturalization after 5 years of legal permanent residence, but they had this rebuttable presumption of having broken continuous residence. How do you rebut the presumption of broken continuous residence? By showing ties to the United States. Okay, so what we did with these cases were, and it's not that all ties to the United States in this context are created equal. No, there's some that matter more. Okay, continued employment in the U.S., presence of the immediate family members of the applicant during the applicant's absence. There's 4 that really matter. But then there's a catch-all category, which is any other thing that shows ties to the United States. So in the catch-all category, I mean, we put, gym memberships in. We put continued cell phone service bills in the United States, continued financial accounts in the United States. We even used in a couple cases the person who paid a yearly membership for a domestic affinity organization while the applicant was outside the United States, right? And so all these types of things, right? Some of these things, some of those factors, some countries will ask for those. They may say, hey, where did you keep your accounts, for example? But some of those others, they may not ask for those. But if you build those ties and you keep them close to your chest, I mean, that could just be something that you save, okay, that you keep in case down the line your connection to a country is tested. Okay, so what I tell my clients, okay, for citizenship is you want to build some ties, okay? And what those ties could be, obviously, is highly person specific, okay? So people have different capabilities, different interests. One thing that I think is at the top of the list, if the person can do it, is learn the language, know the language of that country. I think it's a bad look if you are a citizen of a country and you cannot speak the language, at least on a basic level, and then you're in a third country claiming some sort of citizenship benefit of that second country. I think that's a bad look. And we talked about the Chinese national who got Vanuatu citizenship by investment, okay, and then he went to the Philippines and he couldn't even speak English. And the Philippine Immigration Authority that detained him, they cited that as one of the reasons they suspected that he had a fraudulent passport, that he didn't know anything about Vanuatu and he couldn't even speak English. So that's a high effort task, learning the language, right? As Jay will tell you, for simplified naturalization, you got to know Hungarian. But in my opinion, that's an impactful one. Okay, when you're talking about building ties to the country, and then other ties could be, whatever little things, okay, that show your connection to the country, right? So I think that's, I don't think when you get a citizenship in a foreign country, if it's by descent, by distant descent, by investment, or by merit, that your job is over. Okay, I think, to be honest, I think of it kind of as, you should do little things, okay, to build those ties and build up to defend against a potential challenge to that citizenship down the line. And I'm not saying you got to make it your whole life or spend, hundreds of hours per year doing this, but little things, okay? And remember, I believe that when you're talking about ties, okay, documents that are contemporaneously dated are king, okay? So not that after the fact, 10 years later, you're trying to prove that you had ties 10 years ago. And so you're generating documents 10 years later. I'm talking about an email, a receipt, an invoice, okay, a membership letter that has the date, okay, that's issued on the date during the time period that you're trying to actually show that you have the ties to the country. That's king, okay? Because after the fact, everybody obviously, if they're trying to defend or stave off a challenge to their eligibility or a challenge to their citizenship, everybody's going to be, generating a spate of documents, then trying to look backwards in time and interpret past events, okay, to their benefit, right? But the benefit that those documents have, like I said, that are contemporaneously dated, is that they're generated at the time, right? So unless you're, fraudulently backdating documents, and that's obviously not what I'm talking about, but unless you're doing that, that proves that in real time at that date, 10 years ago or 7 years ago, or whatever, you had those ties to that country. Okay, so this is something I'm writing an article. I'm working on an article about this. Eventually, I'll publish it. It's just going to be basically my general thoughts on kind of on low effort things that new citizens can do to build ties in a way that and generate evidentiary documents to basically stave off a challenge in the future. All right, we got Chris here. Okay, what do we think here? Anybody want to dive in and give their thoughts?
Sure. So learning the language is definitely a real cornerstone of the establishing a very apparent tie, especially if it's a language like Hungarian, Ukrainian, Serbian, some Eastern European language, or some language that's really quite obscure. Because not just at that point, you're not just speaking the language of that country, but you're speaking the language that really is only of that country or of that region of the world. So you're able to show that you're not just a citizen of their country and a member of their nation on paper, but that you try your best to be in practice.
Yeah, absolutely, Jay. I absolutely agree. And I hope nobody takes what I'm about to say as a suggestion that I think countries should implement language requirements for citizenship by descent. I'm not saying that in any way, shape, or form. But what I'm saying is that if you learn a country, a language, like a relatively obscure language, like Hungarian is not French, okay? People don't go and just say, hey, I'm going to major, or very few people go and say, hey, I'm just going to major in Hungarian, okay? But I'm, Colombian, for example, right? But people do that all the time with French, with Spanish, Arabic, Russian, Mandarin, right? But people who go and learn Hungarian, especially if they have some sort of ancestral tie, okay, it's a massive, I mean, if you're from the Bitcoin world, you'll know what proof of work means. Okay. It's massive evidence of proof of work. Okay. Basically, you're undertaking this endeavor, which doesn't have so many knock-on benefits outside of just, wanting to know the language for affinity reasons, basically. So I can understand. I don't say that countries should do this, but I understand why they do this. And the other thing is this. So when Viktor Orbán passed this legislation in 2011, we're talking about the Hungarian context. So let's just take it a little bit further here. You know, I thought, so I wasn't aware of it back then, but I became aware of the law a couple years later, I think about 2013, 2014, right? And first I thought to myself, okay, that's interesting, right? He's making a play on he's making a geopolitical play on citizens of countries, of his neighboring countries, and that obviously pissed off and created some reactions from other countries, right? Because when you pass a law that basically makes 10% of your neighbors' citizens eligible, it's a play on sovereignty. It can be looked at as a play on sovereignty to some extent, right? But I thought to myself, okay, but what about the people that qualify for Hungarian citizenship if they learn the language, but they don't know the language? Are they really the types that he wants? He's trying to get cultural Hungarians. Are they really the type that he wants if they're just picking up, if they're just learning the language for the purposes of getting the benefit? And then it occurred to me, I thought, well, if you learn the Hungarian, you don't learn a language, okay, to fluency or medium fluency without learning a lot about the culture. It's just, I don't think it's possible. I don't think, even if you hate a culture, you say, I don't want anything to do with this culture. If you learn that language to medium proficiency, okay, realistically, or to fluency, whether you want to or not, you're going to pick up knowledge of the culture and some of the culture. And so it occurred to me, okay, it's actually kind of ingenious, because even for the people that just say, no, I'm picking up Hungarian citizenship or Hungarian language because I want the citizenship, because I want EU-wide residency, he's manufacturing Hungarian citizens and cultural Hungarian citizens by doing this. Okay, because if you take just a guy, a Hungarian American guy, never knew the language. Okay, he says he just learns the language to pick up Hungarian citizenship. Well, what Hungary's done effectively is add more. They've manufactured out of thin air another cultural Hungarian on planet Earth, right? So I definitely understand it. I get it. I don't say that every country should do it, but and then also hand in hand with that is, if you know one of those obscure languages and you're claiming and you have citizenship in that country, I just think it's if you find yourself in a tribunal, whether it be judicial or even at the administrative level in a foreign country, and they're saying, no, you don't really have connections to that country, and you say, well, actually, I speak this obscure language fluently. Okay, there's only 10, let's say 10 million Hungarians on Earth, and there's only 11 million Hungarian speakers on Earth. Okay, that's pretty good. It's pretty good evidence, right? So yeah, I would agree absolutely with everything you said, Jay, about specifically how the more obscure the language is, the more I think it's prima facie proof of ties to the culture and the country.
Does that mean that languages that are more widely spoken in multiple countries, like Spanish or French or English, don't offer as much value in the ways of providing genuine links?
Yeah, I would say so. I mean, English, hundreds of millions of people learn English, not because they want any association with England or the US or Australia, but because it's the international language of commerce, right? So
Right.
to me, yeah, I would definitely say, obviously learning the language has other benefits, but as far as kind of like narrowly tying the knowledge of the language with affinity and connection to a culture and country, yeah, I would absolutely say that those lingua francas have less value in that regard. I mean, French is a funny example, right? Like, if you speak French, I'm going to make a generalization here. Okay, so please don't yell at me if anybody disagrees with this. But if you speak French but don't speak it well, you don't get that much of a benefit of the doubt in France, or you don't get necessarily a presumption that you have connection or ties to the country of France. I'm speaking generally here. I'm generalizing, right? But if you speak, even Persian, right? For example, Persian. Iran's a country of 90 million. There's 3 countries that speak Persian or some variety of Persian. It's Iran, Afghanistan, and Tajikistan, and very limited number of people relatively who are not in one of those countries or have background from those countries speak Persian. If you speak Persian, the most broken, messed up Persian in front of a native Persian speaker, they're going to kiss you on both cheeks and just be amazed and just assume. They're going to assume you have some sort of connection to the country, the language, the culture, etc. I think that's way, way, way less the case for lingua francas. And I'd qualify probably about, maybe seven languages I would qualify as lingua franca in the way I'm saying. English, Spanish, French, Mandarin, Russian, Portuguese, maybe, etc. But Jay, what do you think about David's question?
I would say that yes, especially in the case of English, French, and Spanish and Arabic, because there are so many countries that speak that language natively, and so many people who learn them as second languages for some kind of commercial or career goals. Even Portuguese, for example, I learned Portuguese, and I studied abroad in Brazil for a year. The amount of people that assumed that I had ties to Brazil or to Portugal based on learning Portuguese was massive. Every other Uber driver who I got into a cab with asked me if I was Brazilian or if I had a Brazilian parent. So even languages that have lots of native speakers, that have few second language learners, could also serve that sort of tie.
Great point. Okay, great insight. So maybe we're stretching a little too far to include Portuguese in that list. Yeah, I think you said it beautifully. The distinction, the important factor is not how many people speak the language; it's how many second language speakers are there of that language. That's kind of, in my opinion, the relative inquiry into to the question of how much people associate your knowledge of that language with ties to the country.
Now, does this also tie into things like francophonie and the CPLP for Portuguese, where belonging to a country where French or Portuguese language is spoken, provides a lot of springboard benefits, presently at least?
Yeah, countries that share language, in my opinion, can there's just less friction to creating compacts, covenants, and treaties that kind of allow for mutual, immigration, movement, that type of thing. So, yeah, I think it is the case. I mean, if by luck, this is, I guess, less. I think I cut out there. If by luck you're born into one of the countries, country that whose official language is one of the prima francas, yeah, I think probably on average you're more likely to have some sort of springboard benefit in another country that shares the language.
That makes sense.
Yeah, no, that's a great observation, David. Okay, so I'll just continue on. A couple ideas basically that I had that I wanted to just throw out there, which is, first of all, I'm not sure how much CBI countries are interested in protecting the integrity of citizenships that they issue by investment. And what I mean by protect the integrity is not protect the reputation of the country. They're very sensitive to that. In fact, that's why they've thrown citizens under the bus, in my opinion, very unfairly. Okay, when they naturalize somebody by investment, and then just sometimes even small, slight pressure causes them to act and scrutinize previous applications on that type of stuff. I'm not talking about those countries trying to save their own tail, okay? So those CIUs, okay? But what I mean by the integrity of the citizenship is how interested are CBI countries in putting their naturalized CBI citizens in a position, in the best position possible, to not be discriminated against. And I'm not sure to what extent that they care about this. And by that, I'm implying that I don't think they give much care to it. And part of the reason I think is because there just has not been pressure on them to do so, right? There's just not that much reporting on, given to an analysis that's given to people who got a CBI, and then somehow they were discriminated against, and they were denied a particular, let's say, springboard benefit based off of the CBI. But I do believe that if they care to do so, okay, if they're really, I think it would take them being pressured to do so. So people putting pressure on them. I think CBI countries can do a few things actually, okay. And what, first thing that comes to my mind is if they make, it shouldn't be easy, in my opinion, to look at a person's proof of citizenship and determine how they got the citizenship. Okay, I think that's a first thing. Okay, first level. Okay, of protection that can be made. Okay, to the extent possible. Now, obviously, if you have a certificate of naturalization, well, that implies some piece of information. It implies you weren't born a citizen, right? You naturalized somehow. So I'm not necessarily talking about the naturalization certificate, but if you have a certificate of naturalization, I don't think it should have any type of, information, okay, data about how you got it. And definitely you don't want it to say, here's your certificate of naturalization by investment or by merit or by exception, okay. Similarly for any type of mentioning on the passport, okay. And I would actually I would like to see countries take that, CBI countries take that even a step further, and not just avoid broadcasting, okay, on the public facing documents, but I would like to see some sort of legislation that actually restricts the data, okay, of how a person got their citizenship in the country, especially if it's by investment, okay. So obviously I'm totally against registries, when a person naturalizes by investment, that type of thing. But these are things that countries could do, okay, to just provide a little bit more friction, or a lot more friction, to foreign entities and countries that are trying to discriminate against their citizens by investment. I think they don't do it because there's just not pressure to do it, right? And it obviously would take, it takes pressure. Generally it takes political pressure to move countries to do it. But I think if these CBI countries don't start doing that, I think we're going to just start seeing more and more CBI citizens by investment get their mobility benefits, their springboard benefits picked at little by little, like death by 1,000 cuts, right? So that's definitely something that I want to see. And I just there's this issue that that I talk about, other people have talked about, which is 95+% of any content, and I'm using the term content broadly, so news, marketing, articles, analysis, space, like this content, I would count a space like this as content. 95% of content about CBI countries is produced by agents and salespeople trying to shield the benefits of this, the CBI. They don't want to talk about drawbacks and weaknesses of the CBI. And I get it. Obviously, they're in a business, they're selling things, okay, and so they don't want to highlight those things. But it has kind of this downstream effect that when a CBI acts poorly, okay, when they're naughty, especially towards one of their naturalized citizenships, one of their naturalized citizens by investment, they don't get much blowback. They don't get much pushback, okay? Because those agents, yes, they want, I do believe that CBI agents and salesmen do want the citizenships by investment to retain their value. So at very least, they're not contacted by one of their clients 3 years down the line and say, what the hell, man? You sold me this thing and now I can't use it. But for other reasons as well. But there's a tension, okay, for those people that are, highly dependent on how those CBIs are perceived, because if you're an agent and and you're selling, let's say 3 or 4, a lot of agents don't sell just one CBI, they sell multiple. But if you're selling 3 or 4, and 1 or 2, if there's news that comes out that 1 or 2 of those CBIs has really acted poorly vis-a-vis their applicants or their customers, I would call them, so citizens who naturalize there. Well, if you publicize that too much, I mean, you might say a huge sales dip, okay, in the coming months, and you might be out of business a year later. So as a result, these CBIs don't get that much pressure. And I mean, there's a few actually. There's a few. We got there's a few people that have come out there. Kenneth Rehawk, right, is this guy, fraud investigator, and he writes all about all the bad actions and actors in the CBI industry. I think he goes a little too far, and I've said that to him, and I've even I've even commented on his post. I think he goes too far in vilifying the entire concept of CBI and the entire industry. But there's no doubt there's at least a kernel of truth in a lot of the stuff that he writes. Okay, so he's been an interesting character that's kind of exploded onto the scene in the last year or two. But there's just not that much even-handed treatment of the behavior of these CIUs, in my opinion. And as a result, I think there's a lot of people out there that have fragile citizenships by investment, and a lot of that fragility I think is latent. It hasn't come to the surface yet. I guess I'll just pitch my post on X last week. One thing that I was a little bit heartened to see was that it became, was publicly, news was broken that Andrew Tate got Vanuatu citizenship by investment. I don't like Andrew Tate. I think he's a scumbag. But news was broken, okay? And then The Guardian, which is a newspaper that hates citizenship by investment, contacted the Vanuatu CIU and naturally started writing articles on it. And the Vanuatu CIU, to their credit, okay, they basically said, there's no, we reviewed his application. We don't think there's any fraud in it, and no action is going to be taken. Now, I didn't like the fact that they admitted that he was a citizen, and they kind of, commented on the status of their inquiry of his citizenship. I do not like that. So I think that should be kept private. But the fact that they arrived at the conclusion that, hey, we're not going to try to rescind or revoke his citizenship for, conduct or speech that happened after the naturalization, that very much I liked. I liked that a lot. And that actually, despite Vanuatu's, the other problems of the CBI and the fact that they lost their visa-free access to Europe, that was good news, I think, for Vanuatu, kind of holding firm on one of the most controversial, if not, you could argue that Tate is the most controversial online figure, especially among, the leftist types, of the last several years. But applicants have to dig. I mean, if you're an applicant, or let's say even before you're an applicant, you're just a potential customer. A lot of people come into this space. People come to me. They come to the space. They get a consult with me, and they found out about this world of second citizenship and third citizenship, and they binge on the content. This is a common thing I see. They binge. This is really exciting. They read The Sovereign Individual or whatever, or they know one of the big influencers in the space, Nomad Capitalist or whatever. They binge content. And there's different stages. And the first stage is, how many citizenships can I get? What can I get? All this. And they have to really dig hard to actually find any discussion, okay, of back-end vulnerabilities of these citizenships. And that's, kind of a shame, right? Because that's, that's not putting people in the best position to really, long term, 20, 30, 40 years, acquire mobility assets that are robust and are going to last for them.
I wonder if we could talk for a bit about vulnerabilities, not from direct disclosure, let's say through a database of people who have obtained CBI, but maybe inferred, inference of how a person came to have a particular citizenship. For example, if a government knows that a certain person has not resided in another country, but is a citizen of that other country, can they infer that that person either obtained the citizenship through perhaps descent or citizenship by investment or exception or some other manner other than residence? It seems kind of obvious now that I'm saying it out loud, but I'm wondering what can be inferred by a person having multiple citizenships without having resided in some of those countries.
Yeah, I mean, what you just said, I mean, they can infer, okay, that might be a possible, let's say increased possibility that the person obtained the citizenship by method other than, a period of residency leading to naturalization. But yeah, the more information you know about a particular person's life, if you have deep knowledge of how citizenship and residency works, the more you can kind of map out probabilities and possibilities, okay, of how a person obtained, certain citizenships. You can even infer about people's lives based off of looking at their passports sometimes, right? The place of issuance of the passport, okay?
Mm.
Plenty of countries will only issue you your passport in that country or the country you are resident in, okay? So if you look at somebody's passport, let's say it's, X country's citizenship, passport issued, and it says that it was issued in Y country, and if you know that that country X only, like I said, issues passports in its own country or in the country of the applicant's residence, then you can infer that there's a good chance, not 100% chance, but there's a good chance that that person is resident in country Y or was resident in country Y around that period of time. So yeah, I mean, especially with AI, I mean, I've written about this before. Little bits and pieces of information that are thrown off by a person's life, okay, if you throw that into either present it to somebody who knows how these things work, okay, and can research it, or throw it into AI, you can start putting together, in my opinion, a lot of inferences about that person's life, and specifically where they live, where they lived, and where they've been physically present, even if they haven't actually been resident there or lived there, and where they're citizen of, okay, and where they may be citizen of, and then also even where they might be citizen of by operation of a law, even if they didn't know it's the case, right? If give you an example. I mean, if you know that somebody has an Iranian father, okay, and that person was, let's say you don't know anything else about their connections or lack of connections to Iran, okay, at all. Or let's say the person hates Iran, they've spoken against Iran, they hate the country, don't ever want to visit, none of that, okay. But you know that they are, that they have a father that was born in Iran, okay. If you know about Iranian nationality law, okay, you can infer that that person is probably a silent citizen. They're probably a citizen by operation of law at birth, okay. And you could take it a step further, okay, and start, as I wrote before, okay, citizenship obligations, okay, international law recognizes the ability of countries to impose obligations and law extraterritorially on their own citizens. Okay, so if you take what I just said a step further, okay, you could start, can start working out potential vulnerabilities that person might have. Okay, if they ever travel to Iran or pass through Iran or that type of thing. And I don't mean to pick it's probably bad idea that I picked an example of Iran, because somebody's going to probably listen to this and think, oh, it's a big bad country, only Iran does that type of stuff. No, in fact, it's other countries. It's actually Western countries that more, in fact, try to really impose extraterritorial obligations on their citizens and enforce them. But this is just an example. So this is why I say, this is why I'm increasingly, my opinion has shifted on this issue of citizenship privacy. The more I've learned over the years, the more I've realized, and obviously, the bigger AI has become, the more I've realized how critical it is to be private with a lot of those facts, not just your second citizenship, but a lot of facts that, if combined with other public facts known about you, can be used to in combination to infer some pretty important things about you. Okay, so it's 12:03. We started Pacific Standard Time. We started at 11:02. We've been going for just about an hour. We said that for the spaces, our default was going to be 1 hour, and we could break the default in times where we have like a really bumping conversation and we need to extend. But we're pretty much at that hour time period. I think now is probably a good time to wrap up this space. Okay, it's been a good discussion. If anybody has anything else that they want to add or subtract, by all means, please jump in and let us know. Otherwise, at this point, I would normally solicit topics for our next mobility space, but we already have the topic for the next mobility space, and it's actually intimately related to the topic that we just dealt with. Okay. In fact, we may have actually discussed so much of the topic for of what I had scheduled next that maybe I should actually change it. But here's what, let me ask the group. Okay, this is what I had scheduled for our next mobility space, and you guys tell me if you think that we addressed this already sufficiently, or if we should go ahead with this. For mobility space number 43 on October 20th, this Monday, 11 a.m., I have the topic as the future of citizenships by investment. And we touched on it. We didn't actually go that deep, but we did touch on it a bit. So what do you guys and gals think? Should we forge ahead with that topic and really focus on where we think? And what I mean by CBIs is both the state of the industry as well as those people who got citizenships by investment, their individual citizenships. What do you think?
I personally think that there is some more to be covered in that domain, but I think that we did cover here the very important implications of how countries' policies are shaping up to restrict to some degree the freedoms of people who are citizens by investment.
Okay, David, what do you think?
Yeah, I agree. One of the topics that was suggested previously, I think maybe by you, Parvis, was freedom of speech issues internationally. And, sorry to be American-centric. I think most of us here on the call probably are. But I think it would be particularly interesting to go into that and, consider, what protections are U.S. citizens afforded right now internationally, and what risks would renouncing that U.S. citizenship pose to former American citizens who no longer have that protection of freedom of speech?
Yeah, that's an interesting topic. The Speech Act, the U.S. Speech Act of 2010, protects U.S. citizens, residents, and U.S. companies from enforcement of foreign defamation judgments in foreign countries that have a standard of free speech that falls below the U.S. First Amendment. So if a person is a U.S. citizen and they cut ties with the United States, right, they would be hamstrung. I mean, they would definitely have less protection from protecting against a judgment in the United States, right? Now that's limited, right? That's basically a judgment, enforcement of a judgment, of a foreign judgment in the United States. So that means basically the person would have to have still at least assets in the United States, right? So yeah, that's definitely an interesting point, an interesting topic. If we talk about speech for mobility, what I would think would have to go hand in hand with that is ETAs, electronic travel authorizations, right? Because we are seeing, as I've said before, visa-free is becoming visa-light. Visa-light is ETAs now. And we are seeing, I mean, the United States, unfortunately, is paving the way on, on this. We protect our citizens' speech, but we don't protect the speech as much, at least not this administration, of foreign citizens. But we are seeing, okay, and I think we're going to continue to see, I've written this before, that countries are going to look at canceling or denying an ETA of a person for their speech online. So I think the rise of ETAs would probably have to go hand in hand with that topic of speech and mobility. Okay, those are both good topics. I'm on the fence. Anybody else want to suggest a topic or give an opinion on whether we should just forge ahead with the future of CBIs for our next mobility space?
I can say that I really like the speech and citizenship topic. I think it goes hand in hand as well with keeping citizenships private that you hold, because I guess that's part of the discussion of the topic. But if you are known to hold certain citizenships and say certain things, then that could keep you in good standing or get you out of good standing with one of your countries of citizenship.
Yeah, exactly. And Jay, I don't know if you saw my tweet from I think 2 months ago. I wrote hidden citizenship attack vector, and I wrote about how I believe one of the main reasons. I also referenced it in my short video on second citizenship privacy. When you tell somebody or the world what countries you're citizen of, you're telling everybody in the world all the sets of laws that you are subject to extraterritorially. That's a huge vulnerability, okay? Especially if one of those countries, okay, is keen on censoring the speech, okay, of people in the territory or their citizens abroad. And I'll just spell it out in a very granular example. Okay, if you're citizen of 4 countries, okay, and one of those countries imposes draconian speech laws, okay, especially extraterritorially on their citizens, okay, you could be a loudmouth online, like me, for example, me personally, right? And if one of your enemies or somebody you pissed off or somebody that just doesn't like you at all, okay, knows that you're a citizen of that country, they can start bringing you to the attention of prosecutors in that country. And this is not that hard. In fact, it's already happening at a high crude level, and it's just going to become easier and easier to do with the advent of AI. It's very easy for AI to just task AI with scanning all the laws of a particular country and also all the public statements of a particular person, give an opinion on whether the person has broken the law of their country, okay, and then to task AI with sending what I call like a prosecution package to the prosecutors there. Maybe AI is not going to be accurate. Okay, maybe it's going to have middling accuracy. I've written about that before, but the cost of the person to task AI with doing that is so low. It's just easy. You can just spam these things out against your enemies. Okay, and the more capable AI becomes, the more capable people are going to be of doing this. So I think that's a huge topic. It's latent. I think it's a latent topic. It's not come to the head yet, but I think this is going to come to a head soon. Okay, we had, so King of Sardonica, I think, cannot speak, but he wrote still more to cover on next week's topic. So I'm going to take that comment as a vote in favor of continuing with the proposed next week's topic of the future of CBI. This is what I think I'm leaning towards. I think I'm leaning towards keeping next week's topic as is, okay, because there are more angles that we could talk about related to the future of CBI. And then maybe the very next topic after that, we'll go into speech and mobility / ETAs. And, one thing I want to do, so I love these spaces. I love talking, but I kind of would like to move towards trying to have for each space a guest that is kind of, everybody would still be able to speak. We'd still have the mic open to everybody, but a guest that could kind of be like a partner, I guess, on that particular topic, a guest that's specifically interested in that topic or maybe an expert in that topic. I kind of want to move a little bit towards doing that for some of these spaces. A few people that I have in mind. So Preston Byrne is a free speech and tech lawyer. He's been really active about fighting the attempts of the UK's Ofcom to regulate US-based websites that have customers in the UK. He might be somebody that I'll invite. I don't know. He's a busy guy. I don't know if he'd be able to attend, but I might invite him for the topic about speech and mobility. And then if we talk about the future of CBIs, it might be short notice. Today's Thursday for Monday, but I would like to get somebody in that's to co-host that could speak about the future of CBIs and specifically kind of that negative aspect. I don't mean to be a negative Nelly, right? But very few people cover this this aspect. So I'd like to talk about it. Maybe 262. Are you guys familiar with 262? He's a real small guy. He's only got like 11, 12 followers, but he's kind of he kind of calls out mobility influencers and calls out a lot of the weaknesses of CBIs that get hidden. Maybe he would be somebody that would be good to invite and talk for this topic. So, okay, I think I have an idea of what I'm doing. Any last opinions? I value guys' opinions, especially the regulars on the spaces. Any last opinions on how to handle the next topics before we end today? No? Okay. So I'm going to decide in the next hour or so whether I'm going to keep ahead with the scheduled topic for the next one. But either it's going to be either it's going to be space number 43 or 44. We're going to get right into the freedom of speech and mobility / ETAs topic. That's a hot one. I have a feeling that's not going to be the first space we have on that. I think we're going to have to probably have several spaces on that over time. But anyway, I want to thank everybody for your participation. Thanks to our listeners, especially our anonymous listeners. And either way, our next space is going to be on Monday, 11 a.m. Pacific Standard Time. And the topic is to be TBD today. Thank you, everybody. Have a great one.